Hello friends, this is video number 3 presented by CLAT Manthan in the series related to CLAT preparation, and the title of this video is Introduction to Legal Reasoning. This video is presented by me, Harshvardhan Tiwari. I'm a student at Rajiv Gandhi National University of Law, Punjab, and I've cleared the exam of CLAT in the year 2013. So, taking an example, here the principle is an agreement to do an impossible act shall be void. So this term void means of no value in general term. The factual situation given is Raj was a famous hiker and has climbed a number of peaks in India and Australia in record time. When he was in India, Miss Senti, a rich woman, promised to offer him rupees 10 crores if he could climb Mount Everest in 10 minutes. But Raj was unable to even complete 1/10 of the total distance in the set time. The question is Miss Senti's offer valid? So now we see that we have a principle, we have a factual situation, and we have four options. One is yes, other is no, because Raj has not climbed any Indian peak. Third, yes, because it was done to motivate Raj for setting a world record time. And the option D is no, because it was an offer to do an impossible act. Now we look at all the three things which are given to us: the ingredients, principle, factual situation, and the options. The principle has limited our knowledge by saying that an agreement to do an impossible act shall be void. So when we look at the factual situation, what we see is Miss Senti here makes an offer to Mr. Raj to climb Mount Everest, which we know is the world highest peak, 8,848 meters, in just 10 minutes. So, what do you think? Is this agreement for doing an impossible act? And if it is yes to this question, then it shall be void. So, the question is Miss Senti's offer valid? So, it is not at all, because how can a person, Mr. Raj, can climb Mount Everest 8,848 meters in just 10 minutes? So we eliminate the option which contain the term yes. So we eliminated option A and option C. So we are left with two options, option B and option D, with no as answer and an explanation attached to it. Now we look at option B. It says no, because Raj has not climbed any Indian peak. So does it go with the principle given or the factual situation? Apply your common sense. Can this be an answer? No, it can't be, because it is not at all related to the principle given to us. Now we look at an option that is our last option, option D, which says no, because it was an offer to do an impossible act. And this looks a feasible answer to us. We could have also reached to this option D when we eliminated the above three options. So that we could have also done. But when we apply the principle to the factual situation and look at the option, we can eliminate three. The remaining one is the answer. In this case, option the reason I have already told you, as the agreement involves the performance of an act which is impossible, the offer is invalid. So the when you were looking at this particular question, there would have been two doubts. What is a contract? So what is this term agreement? So there comes the aspect of legal knowledge. You need to also prepare for this particular aspect, because the question in CLAT revolves around both aspects, like legal reasoning and legal knowledge. Contract is an agreement enforceable by law, and this word has been described in Indian Contract Act 1872. What is an agreement? An agreement is offer plus acceptance. Example we have seen there were three things. The three things, or we can call them ingredients of a legal reasoning question, were factual situation, which comprise of the facts, hypothetical in nature. On these facts, the law is to be applied. So, where was this law given? The law was given in the principle. The third important ingredient of legal reasoning questions is options. They are usually four in numbers, and selection of the right answer or the right option is only going to fetch you marks. So, all you need to know is the trick of applying the law to the facts. How to apply the law to the fact? The law, which I have already told you, is called principle in the question of legal reasoning, and the facts are the hypothetical factual situation provided to you. What you can do is you can use the process of elimination. Like I have done in the example, we had four options. We tried to eliminate three of them. The one remaining was the correct answer. Second is you can eliminate the options that is based on common sense or talk about a solution because of the principle of natural justice or likewise, which is nowhere in the principle. The important terms are which is nowhere in the principle. You have to limit your knowledge to the given set of facts. The factual situation that is provided to you, you have to apply the principle which is given to you. You don't have to use your prior knowledge of law on the particular question. If it is a big principle question, then break the principle into several parts and then try to apply it into the factual situation. Dear friends, I think this introduction to legal reasoning would have been helpful to you. If you have any query, feel free to contact us on our official FB page of Clatmanthan. You can mail us your query at clatmanthan@gmail.com. And our next video will be on the art of journal knowledge preparation. You can like, share, and subscribe to our YouTube channel.